Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to talk about different issues regarding when you commit a crime and whether or not, in this particular case, in this video, when are the exceptions when you don't need a waiver, okay? Pretty much, for all intents and purposes, if you commit a crime involving moral turpitude and you try to come into the U.S. either as a non-immigrant or as an immigrant, when you try to adjust, if you're in removal proceedings and then do an adjustment or something which requires that you be admitted, generally speaking, and there are exceptions to this, but generally speaking, if you commit a crime of moral turpitude, you are inadmissible and you need to do a waiver. Now, if there is a way that you don't have to do the waiver, well, by all means, you need to try to do that because waivers are not easy to get. I've had some people who come in and they say they filled out the form I-601 and they submitted and it was denied. I go, well, what else did you submit? And they go, nothing. They just filled out the form and said they're going to suffer hardship. And of course, it's much more complicated than that and requires much more evidence. So if there's a particular law or way that you don't need to do a waiver, then you need to look into that, or at least get an attorney to tell you whether you need to or not. Okay, and there's ways of arguing it. So first of all, what really is a crime of moral turpitude? What is that? Well, basically it is a crime that you have to have the intent in which to commit it. Okay, so let me just give you an example. Let's say that you get convicted of a DUI, and in different parts of the country this is adjudicated differently, but generally speaking, if you get a DUI, that is not a crime of moral turpitude because you don't have to have an intent in which to be convicted of that crime. You get out of the car, they take the breathalyzer test. The breathalyzer test says you're 0.8 or 1.0, and that's all you need. That's it. It doesn't matter whether you intended to drink that much or whether you intended to be drunk. The fact is that the statute says if you have a blood alcohol level of this amount, then you can be convicted of the DUI. So that would not be a crime of moral turpitude. Now, what would an example be of a crime of moral turpitude? Well, one could be assault. Okay, you intended to either hurt or to scare somebody in some manner that was unlawful, or battery. You intended to hit somebody. Okay, so for example, to be convicted of battery, you need to have intended to actually hit the person. So if you're, for example, standing on a bus, the bus, some bicycle, a person riding a bicycle goes in front of the bus, and the bus slams on the brakes, and you're standing there, and you, because the bus slammed on the brakes, you jerked forward 2 feet, and your shoulder hit the person in front of you. That in most jurisdictions would not be a battery because you didn't intend to actually hit that person. But on the other hand, if you're standing in a bus and the person looks at you and says, I don't like you because you're tall, and you punch the person, well then that of course would be battery because you intended to hit the person. So a little law lesson here, but basically that's the difference between what is a crime of moral turpitude and what is not a crime of moral turpitude. So, given that, let's go back to the beginning, where basically if you want to come into the U.S., either as a visitor or a non-immigrant, or you're being petitioned by your spouse or parent or brother, whatever, the immigration's job is to find out if you are inadmissible on any grounds. And so, of course, one of the biggest grounds people are inadmissible are crimes. So a crime comes up which you committed in the past, and now the question becomes, are you inadmissible because of it? And the majority of the time, if it's a crime of moral turpitude, you are. But let me give you the exceptions where you're not. Okay, one would be, it's called the under 18 exception, and really it's what it says. If you committed a crime when you were under 18 and you were released from prison more than 5 years before applying for the visa, then you are admissible to the United States, and that particular crime, and again, we're talking about just crimes of moral turpitude. Obviously, if you committed a crime under 18 that is not a crime of moral turpitude, then the attorney would argue that that by itself makes it so you're not inadmissible, okay? But assuming it's a crime of moral turpitude, you were under 18 when you committed it, and you were released more than 5 years before applying for the visa, then that particular crime of moral turpitude won't stop you. And there's other things, other exceptions as well in regards to if you do things when you're under 18. But this exception, this exact exception, falls in this particular area where things were committed when you were a juvenile. Now, keep in mind that you can only have committed one crime of moral turpitude for this exception to apply. So, again, there's other ways you can try to get around it, but if you did something when you were 16 and did something when you were 17, well, this exception's not going to apply. It's basically when you do one dumb thing, and this is how to get out of it. So that's the first exception. Now, the other exception, which is much more common, and which is referred to as the petty offense exception, that is an exception whereby if you fall under it, then you're not inadmissible, number one, and you do not need to file a waiver, okay? And those are two real big things. So you want to make sure that, if you go to another attorney and just, some will have just a knee-jerk reaction and go, well, you got a crime, moral turpitude, boom, you have to do a waiver, or you're inadmissible. That's not the case. Analyze if it falls under the petty offense exception. Now, so what is the petty offense exception? Well, first of all, it applies to turpitude, which one, you were either convicted of, or two, you had elements of the crime. And as a side note, a lot of people don't realize that in immigration law, if you admit to the elements of the crime, it's as bad as the conviction itself. So you could be, interviewed, have a clean record, except maybe an arrest on something, and the officer goes, "What happened here?" And you go, "Well, I was arrested for assault and battery, but I had a really good lawyer who got me off. I mean, I beat that guy to a pulp, and that lawyer still got me off. He was really good." Well, pretty much by doing that, you now have in immigration law, you now have a conviction for purposes of immigration law, and now you are considered inadmissible. But minus that, let's look at the exception itself, the petty offense exception. Okay, there's three elements to the petty offense exception. Okay, so of course the first one is that the crime which you either has a maximum possible penalty of 1 year of imprisonment. And sometimes that's a little hard to find. It's not as easy as you would think. Not every statute has statutes correlating to that say the maximum possible penalty for this particular statute is such and such. So you need to make sure that the attorney that is doing this for you knows how to find out and determine what the maximum possible sentence is. If there's an ambiguity in the law, then of course the argument would try to fall under this provision showing that it is a maximum possible penalty because of the nature of the crime and so forth. That's the first element. Now the second one is that you cannot have been convicted or you cannot have been sentenced to more than 6 months imprisonment. Okay, it doesn't matter how much time you actually served. It doesn't matter if you served 3 days or if the judge gave you a 4-year suspended sentence and you didn't have to serve a day. It's what that judge actually sentenced you to. Okay, so the sentencing of the crime must have not have been more than 6 months. So in some cases, depending upon whether you qualify or don't qualify for a waiver, let's say that you were sentenced to more than 6 months, but you don't have any qualifying relative for a waiver, so therefore it might be impossible to get a waiver. It might be possible to go back to criminal court and try to reduce the sentence for various reasons in order to fall under the petty offense exception. Okay? So that would be the second item that you have to look at. And third, you must have only committed one crime of moral turpitude. Okay, only one. So if you have committed two, and it falls under all the other elements here, you're not going to qualify because, of course, you have committed two. So that might necessitate trying to vacate the second crime, or you might have to just do a waiver. But using my example earlier, if, for example, you have a DUI and an assault, then depending on whether the assault falls under the petty offense exception, meaning, you look at the maximum sentence that was given, or that was less than 6 months, that the maximum possible sentence for this crime is less than a year, then you can still qualify for the petty offense exception because the DUI doesn't make you inadmissible. It's not a crime of moral turpitude, and the only other crime falls under the petty offense exception. So, given that, there are different ways of analyzing the petty offense exception and the under 18 exception to see if you can slide through immigration without having to do a waiver. There's a lot of officers and a lot of officials that might not be fully aware of this exception or these exceptions and might not think you fall under it. So what I do is, if they're coming in as a non-immigrant, of course, I will prepare a legal brief explaining exactly what the conviction was, why they don't fall under the petty, or why they do fall under the petty offense exception, and why they are not inadmissible. Okay, so it's crystal clear once the officer reads it. So if you like the video, click like, go ahead, subscribe. I put out videos usually once a week, and then we go from there. So that'll do it for this one. Thank you.